This is the post-trial memorandum opinion in the case of Vicelli, Perry, and Villinger versus Duffy, DeFiore, Flanders, LaPuma at Ionic Digital. This post-trial decision resolves an expedited challenge to 1. The adoption of a board resolution reducing the number of director seats up for election at a corporation's upcoming annual meeting, and 2. The rejection of a director nomination notice under the corporation's advance notice bylaw. In 2022, Celsius Network LLC, a cryptocurrency lending platform, filed for Chapter 11 bankruptcy before the U.S. Bankruptcy Court for the Southern District of New York. In January of 2024, Ionic Digital Inc. emerged to hold and operate digital currency mining assets formerly owned by Celsius, with many Celsius creditors becoming Ionic stockholders. By the summer of 2024, Ionic stockholders had already begun to publicly vent frustration with the company's leadership, and, in particular, with their failure to publicly list Ionic shares. Soon after, Ionic stockholders Veton Vicelli, Brett Perry, and Christopher Villinger partnered with Figure Markets Inc. and GXD Labs LLC, non-parties that do not own Ionic stock but have proposed commercial arrangements with Ionic, first to seek stockholders' support to call a special meeting of stockholders to replace certain directors of Ionic, then to run a proxy contest at Ionic's first annual meeting. In the face of the impending proxy contest, Ionic's classified board of directors executed a unanimous written consent setting the date of the annual meeting and resolving to reduce the size of the board to eliminate one Class 1 director seat up for election at the annual meeting. Ionic did not immediately disclose the board reduction resolution, but did announce the annual meeting date, triggering a 10-day window for any stockholder to submit a director nomination notice under Ionic's advance notice bylaw. Plaintiffs, with financial backing from Figure Markets and GXD, submitted a notice nominating candidates for the 2 Class 1 director seats that plaintiffs believed were up for election. Ionic then disclosed the board reduction resolution, and the board rejected plaintiffs' nomination notice for failing to disclose and attach copies of all agreements between plaintiffs, Figure Markets, and GXD. In this action, plaintiffs contend that Ionic's directors breached their fiduciary duties by adopting the board reduction resolution and rejecting plaintiffs' nomination notice. Applying enhanced scrutiny under UNOCAL with sensitivity to the stockholder franchise under Blasius, this post-trial memorandum opinion concludes that Ionic's directors breached their fiduciary duties by reducing the size of the board, not for a valid corporate purpose, but as an inequitable defensive measure. It separately concludes that the board properly rejected plaintiffs' nomination notice under Ionic's advance notice bylaw. To restore the stockholders' ability to elect 2 Class 1 directors at Ionic's annual meeting, an injunction will issue directing the board to reopen the 10-day nomination window under the advance notice bylaw to permit any Ionic stockholder to submit new director nominations. Although the board urges that plaintiffs should not get a do-over after failing to comply with the advance notice bylaw once, they offer no good reason to deny plaintiffs the ability to submit a new nomination during the reopened window, so that, with the benefit of full disclosure, Ionic stockholders can finally decide for themselves who should serve on the board. 1. Background. The following facts were stipulated by the parties or proven by a preponderance of the evidence at a 2-day trial held on May 8th and 9th of 2025. A. Ionic emerges from the Celsius bankruptcy. Ionic is a Delaware corporation that was formed on January 5th of 2024 as part of Celsius's Chapter 11 bankruptcy proceeding before the U.S. Bankruptcy Court for the Southern District of New York. The bankruptcy court approved a plan under which Celsius's digital currency mining assets were spun off into a newly formed entity, Ionic, and many Celsius creditors, including the plaintiffs, became Ionic stockholders. Ionic entered into a management services agreement with the plan's sponsor, US Bitcoin, now known as HUD-8, under which HUD-8 was to provide Bitcoin mining and other services to Ionic. Ionic has a classified board with directors in each of 3 classes, serving 3-year terms. When Ionic was formed, the board comprised 8 directors, including 3 Class 1, with terms expiring at Ionic's first annual meeting, 3 in Class 2, with terms expiring at Ionic's second annual meeting, and 2 in Class 3, with terms expiring at Ionic's third annual meeting. HUD-8 exercised Class B designation rights to appoint 1 Class 1 director and 1 Class 2 director, and a creditors committee appointed the remaining directors. Since November, the board has comprised just 4 directors: Elizabeth LaPuma, a Class 1 director, Scott Flanders, a Class 2 director, Scott Duffy, a Class 3 director, and Thomas DiFiore, also a Class 3 director. B. Ionic's Advance Notice Bylaw. The second amended and restated bylaws of Ionic Digital Inc., effective from June 19th of 2024 to February 13th of 2025, include advance notice procedures for director nominations and business proposals. Namely, Section 2.4 of the bylaws requires that, to be properly brought before an annual meeting, nominations of persons for election to the board must be properly brought before the annual meeting by a stockholder of the corporation who has timely complied in proper written form with the procedures set forth in this Section 2.4. A nominating stockholder must deliver timely notice thereof in proper written form, setting forth all information required under this Section 2.4. If, as here, no annual meeting was held in the previous year, to be timely, the notice must be delivered not later than the close of business on the later of 1. The 90th day prior to such an annual meeting, or 2. The 10th day following the day on which a public announcement of the date of such annual meeting is first made by the corporation. In addition to the notice, a nominating stockholder must also deliver a written questionnaire with respect to the background and qualification of the nominees and the background of any other person or entity on whose behalf the nomination is being made, which questionnaire shall be provided by the Secretary upon written request of any stockholder of record identified by name within 5 business days of such written request. The Advance Notice Bylaw also specifies certain information that must be included in a nomination notice. Pertinent to the current dispute, Section 2.4 3C9 requires that, to be in proper written form, the noticing stockholder's notice must also set forth 9. Any agreements that would be required to be described or reported pursuant to Item 5 or Item 6 of Schedule 13D, or filed as exhibits pursuant to Item 7 of Schedule 13D, regardless of whether the requirements to file a Schedule 13D are applicable to such stockholder or beneficial owner. Item 6 of Schedule 13D directs a filer to describe any contracts, arrangements, understandings, or relationships, legal or otherwise, among the persons named in Item 2, and between such persons and any person with respect to any securities of the issuer, including any class of such issuer securities used as a reference security, in connection with any of the following: call options, put options, security-based swaps or any other derivative securities, transfer or voting of any of the securities, finder's fees, joint ventures, loan or options arrangements, guarantees of profits, division of profits or loss, or the giving or withholding of proxies, naming of the persons with whom such contracts, arrangements, understandings, or relationships have been entered into. Item 7 of Schedule 13D states, the following shall be filed as exhibits: copies of written agreements relating to the filing of joint acquisition statements as required by Rule 13D1K, and copies of all written agreements, contracts, arrangements, understanding, plans, or proposals relating to 1. The borrowing of funds to finance the acquisition as disclosed in Item 3, 2. The acquisition of issuer control, liquidation, sale of assets, merger, or change in business or corporate structure, or any other matter as disclosed in Item 4, and 3. The transfer or voting of the securities, finder's fees, joint ventures, options, puts, calls, guarantees of loans, guarantees against loss or of profit, or the giving or withholding of any proxy as disclosed in Item 6. Item 4, incorporated by Item 7, requires disclosures of any plans or proposals that relate to or would result in 1. Any change in the present board of directors or management of the issuer, including any plans or proposals to change the number or term of directors, or to fill any existing vacancies on the board. 2. Any material change in the present capitalization or dividend policy of the issuer. Or 3. Any other material change in the issuer's business or corporate structure. C. Figure Markets and GXD propose commercial arrangements with Ionic. Non-party Figure Markets is a blockchain-native decentralized custody exchange for digital assets that launched in March of 2024. Non-party GXD is a digital asset and blockchain operating, investment, and advisory business. Neither Figure Markets nor GXD owns Ionic stock. On May 22nd of 2024, Figure Markets co-founder and chief executive officer Michael Cagney proposed to the board that Ionic should list its stock on Figure Markets' Alternative Trading System, or ATS. The board did not accept Figure Markets' proposal. Less than a week later, on May 28th, GXD's co-founder and managing partner, David Proman, contacted the board, expressing a desire to replace Hut 8 as Ionic's management services provider. The board did not accept GXD's proposal. D. Vicelli partners with Figure Markets to call a special meeting. In the 17 months since the company's formation, 5 of Ionic's 8 initial directors have left the board. Ionic has employed 3 chief executive officers, 2 chief financial officers, and 2 chief legal officers. Its auditor also resigned. Meanwhile, because Ionic has not yet publicly listed its shares and transfer restrictions are in place, stockholders cannot sell their shares. In the summer of 2024, Ionic stockholders, including Vicelli, publicly vented their frustration with the company's failure to publicly list its shares to provide stockholders liquidity. For example, in late July, Vicelli filed a letter on the public docket in the bankruptcy action to express concerns over Ionic's failure to list its stock and the, quote, shocking amount of turmoil amongst Ionic's directors and officers. Vicelli called for greater transparency and suggested the only other remedy would be to use the proxy rules afforded to shareholders. In early August, Vicelli posted on social media that it might be time to convene a vote of shareholders to get out of this mess. At the same time, Figure Markets tried to purchase Ionic stock with the intention of advancing a stockholder proposal to encourage the board to list Ionic shares on Figure Markets ATS. Several Ionic stockholders expressed interest in selling their shares to Figure Markets, but Ionic's transfer agent refused the transactions due to transfer restrictions in place. In the following weeks, Vicelli partnered with Figure Markets to seek stockholder support to call a special meeting of Ionic stockholders to effect change at the company. Through outreach on social media, they collected names and contact information from thousands of Ionic stockholders via an electronic form that expressed the desire to remove 3 members of the board. To further that effort, on September 4th, Viselli made a books and records demand under Delaware Code 8, Section 220, seeking Ionic stock list and other materials. Ionic responded that Viselli lacked a proper purpose for seeking books and records, but nevertheless agreed to meet and confer on a potential production subject to a confidentiality agreement. Ionic later proposed a draft confidentiality agreement prohibiting any third party, including Figure Markets and GXD, from directly or indirectly paying, reimbursing, or otherwise covering any fees, expenses, or costs incurred by Viselli in connection with Ionic, the demand, or this agreement. Viselli did not agree to this outside funds provision. On October 28th, Viselli, Figure Markets, GXD, and lawyers at Alshon from Wolosky LLP met with the board. At that meeting, the group encouraged the board to replace directors, appoint a new CEO, immediately list Ionic stock, terminate the MSA, and replace HUD-8 with GXD. The next day, Ionic issued a press release announcing that it had met with an Ionic shareholder and other parties, including Figure Markets and GXD, regarding proposed governance changes and an alternative operating path forward for the company. E. More stockholders joined the effort to effect change at Ionic. Back in August, Brett Perry, then a board observer, reached out to Ionic stockholders on social media. Fellow Ionic shareholders, you've been kept in the dark too long. I'll ensure your voices are heard by the board and management. In late September, GXD asked Viselli whether Perry would be willing to work with the group, and Viselli confirmed that Perry was more than willing to meet and help them out in any way possible, having offered multiple times already. In early November, Viselli separately reached out to Christopher Villinger and several other Ionic stockholders, explaining that Ionic was giving him the runaround about getting the shareholder list, and asked if they would join the 2020 filing with him for books and records. On December 11th, Perry, Villinger, and 7 other Ionic stockholders made a separate books and records demand under Section 220, seeking Ionic stock list and related materials to run a proxy contest at Ionic's upcoming annual meeting. Ionic again refused to produce the stock list unless the stockholders would agree to the outside funds provision. F. Viselli, Figure Markets, and GXD continue to engage with the board, and Ionic anticipates needing a proxy solicitor. Viselli, Figure Markets, and GXD continued to engage with the board throughout January of 2025. On January 6th, Figure Markets Chief Investment Officer Michael Abate contacted Ionic Director Elizabeth LaPuma to extend the olive branch to offer assistance. On January 8th and 11th, Viselli also emailed LaPuma, reminding her that 3,500 shareholders signed a form to call a special meeting and offering to discuss candidates for the board. The following week, on January 16th, the board held a meeting at which it discussed the hostile activists and their books and records request. On January 20th, LaPuma sent Viselli an email responding to unflattering comments posted online, describing his behavior as unacceptable for a putative board candidate and aspiring fiduciary. The next day, Duffy and DiFiore separately exchanged messages about recent social media posts from Cagney discussing the timing of Ionic's annual meeting. DiFiore told Duffy that we should hire a proxy solicitor if we haven't yet. G. The board schedules the annual meeting and amends the bylaws to reduce the number of Class 1 director seats up for election. On February 6th at 7:05 p.m., Ionic's chief legal officer, Laura Schnate, emailed the board a draft unanimous written consent scheduling Ionic's annual meeting for March 17th and setting a February 7th record date. The February 6th consent also purported to amend the bylaws to reduce the size of the board from 6 directors to 5, with 1 director serving as a Class 1 director, 2 directors serving as Class 2 directors, and 2 directors serving as Class 3 directors. Apologizing for the short notice, Schnate asked the board to execute the February 6th consent tonight so that Ionic could issue a press release after we have the resolution signed. 3 of Ionic's 4 directors submitted electronic signatures that evening, and at 10:26 p.m., Ionic issued a press release announcing that Ionic would hold the annual meeting on March 17th. Despite the late hour, Alshon saw the February 6th press release and requested Ionic's director nominee questionnaire that night, setting the 5-business day clock for Ionic to provide a copy. The February 6th press release did not disclose the board reduction resolution. Just a few days later, DeFiore, Duffy, and a lawyer from Ionic's outside counsel, White & Case, exchanged text messages, wondering who plaintiffs are going to put up when they find out it is just 1 seat. The White & Case lawyer joked, "They'll go nuts if they see it's 1 seat." Footnote 55 contains more details on the signing of the February 6th consent. Flanders, LaPuma, and Duffy executed the February 6th consent before the February 6th press release was issued. DeFiore executed the February 6th consent the next morning. At trial, DeFiore testified that he viewed the February 6th consent on the evening of February 6th and believed that he had signed it by pressing a button. The next morning, because he had not received a confirmation receipt, he logged back in again and he saw he didn't hit the confirm button, so he pressed confirm and then received the confirmation. Plaintiffs assert that DeFiore's testimony is not credible because DeFiore's electronic signature, generated by PandaDoc, indicates DeFiore viewed the document at 10:55 a.m. UTC, or 5:55 a.m. Eastern Time on February 7th. According to plaintiffs, the timing matters because under the advance notice bylaw, the February 6th press release qualifies as a public announcement, triggering the nomination window, only if it was released by the corporation following its customary procedures, which require approval from all directors before unanimous written consent becomes effective, as per their bylaws section 2.47F7. Despite the PandaDoc viewed timestamp, I am not convinced that DeFiore was lying when he testified that he approved the February 6th consent on the evening of February 6th. H. Plaintiffs file lawsuits under Section 220 and Section 211. On February 10th, plaintiffs initiated a summary proceeding in this court to enforce their books and records demands. Plaintiffs also filed a separate action under Delaware Code 8, Section 211 to enforce statutory quorum requirements at the annual meeting. I. Plaintiffs deliver a nomination notice identifying 2 director nominees. On February 12th, Ionic sent a copy of its director nominee questionnaire to plaintiffs. On February 14th, plaintiffs, Figure Markets, and GXD entered into an agreement for the purpose of 1. Supporting the nominating stockholders in their efforts to achieve the election of persons they have nominated at the nominating stockholders' sole discretion to the board at the 2025 annual meeting of Ionic. Plaintiffs then submitted a notice nominating Michael Abate and Oliver Weiner for the 2 Class 1 director seats that plaintiffs believed were up for election. The nomination notice summarized but did not attach the September 11th Mutual Non-Disclosure Agreement, or MNDA, the December 10th MNDA, and Solicitation Agreement. The nomination notice did not disclose prior agreements between members of the group, including the first group agreement, September 24th Alshon Agreement, September 25th Mutual Non-Disclosure Agreement, second group agreement, October 7th side letter, third group agreement, or December 6th Alshon Agreement. The window to submit nominations closed on Sunday, February 16th. With Ionic's agreement, plaintiffs submitted completed director nominee questionnaires on Monday, February 17th. J. Ionic discloses the board reduction resolution, and the board rejects the nomination notice. On February 20th, Ionic updated its website to disclose that the board had adopted the board reduction resolution. 1 week after receiving the nomination notice on February 21st, the board's Nominating and Corporate Governance Committee met to discuss director nominations in connection with the annual meeting. At that meeting, the committee concluded that keeping Ms. LaPuma in place would be in the best interest of the company and its shareholders, and determined that the company would not recommend the purported nominees, Mr. Abate and Mr. Weiner, because Abate would not be an appropriate fiduciary, and the company had never heard of Mr. Weiner previously and did not have an opinion. On February 24th, the board met and had a similar discussion. On February 28th at 5:22 p.m., the board's outside counsel at Young Conaway Stargatt & Taylor LLP emailed Schneidt a rough memo advising that the nomination notice failed to comply with the advance notice bylaw. Schneidt forwarded the YCST memo to the board at 5:53 p.m. 7 minutes later, at 6 p.m., the board met to discuss the nomination notice. At the meeting, the board discussed considerations around the protections of advance notice bylaws and how they would operate to protect against the dissident stockholders' failure to disclose information in an attempt to hide information from Ionic stockholders concerning potential conflicts of interest among the dissident stockholders, Figure Markets and GXD, as well as concerns that without complete information in the notice, stockholders would not be able to properly vet proxy solicitations from the dissident stockholders who are financially backed by non-stockholder third parties. After discussion, the board unanimously determined to reject the nomination notice because it failed to comply with the advance notice bylaw by omitting copies of referenced agreements and failing to disclose other agreements. On March 3rd, Ionic issued a press release announcing that the nomination notice was invalid because it failed to comply with the advance notice bylaw. The March 3rd press release explained that, more specifically, the notice failed to attach a copy of the funding agreements between the dissident stockholders and the non-stockholders that financially support the dissident stockholders, including, among other things, through the payment of the dissident stockholders' attorney fees, costs, and expenses. The notice also failed to disclose required information about the plans and proposals for Ionic by the dissident stockholders, their purported nominees, and the non-stockholder investors that are financially backing the dissident stockholders, including Mike Cagney, his company Figure Markets, and GXD Labs. The same day, Ionic's counsel informed plaintiff's counsel that on February 28th, the board had determined that the nomination notice did not comply with the advance notice bylaw. The email stated that Ionic's board of directors made this determination because the nomination notice, 1, failed to attach a copy of the funding agreements between the nominating stockholders and Figure Markets/GXD, and 2, failed to disclose any information about the plans and proposals for Ionic held by the group consisting of the nominating stockholders, Figure Markets, and GXD. On March 5th, while claiming Ionic's belated deficiency notices were pretextual and baseless, plaintiff's counsel sent Ionic's counsel a copy of the September 11th Mutual Non-Disclosure Agreement, September 10th MNDA, Solicitation Agreement, First Group Agreement, Second Group Agreement, and Third Group Agreement. K. The court orders Ionic to produce the stock list in the 2020 action. On March 13th, this court rendered a post-trial decision in the 2020 action, determining that plaintiffs had a proper purpose for obtaining Ionic's stock list. I am convinced that each of the plaintiffs here seeks the stock list materials because he sincerely wants to run a proxy contest to improve governance at the company. Each of the plaintiffs has credible reasons for that purpose. The stockholders want greater transparency and liquidity for their shares, which have not traded for over a year, and numerous changes to Ionic's directors, officers, and auditor raise questions about the company's governance and strategic direction. Ionic suggests that Fiselli does not truly seek to represent the interests of Ionic stockholders, and instead has lent his name to the demand in order to seek justice from individuals who angered him in the Celsius bankruptcy. But it is clear to me, from both Fiselli's testimony and the larger record, that that is not the case. Moreover, even if there were reasons to doubt the sincerity of Fiselli's purposes, both Villinger and Perry have significantly larger holdings in Ionic. Villinger was Celsius's 7th largest creditor and lost in the 8 figures in the bankruptcy, while Perry lost approximately $30 million. Both testified credibly that they are focused on finding qualified, competent managers and a path to liquidity. Accordingly, I find plaintiffs' stated purposes for seeking the stock split are sincere. I further find that plaintiffs are not simply proxies, surrogates, or shills for figure markets and GXD. On balance, for all the reasons I've just explained, I find that the plaintiffs are not proxies or surrogates for figure markets and GXD. L. Procedural history. Plaintiffs Fiduciary and Perry initiated this action on March 3rd of 2025 through the filing of a verified class action complaint challenging board reduction resolution. Plaintiffs moved for expedition and to preliminarily enjoin the annual meeting. On March 6th, the court held a hearing at which it expedited the proceedings in advance of a hearing on plaintiffs' motion for preliminary injunction. The next day, Ionic decided to postpone the annual meeting until 30 days after the court rules in this action, obviating the need for a preliminary injunction. On March 19th, plaintiffs filed the operative amended verified class action complaint challenging board reduction resolution. The amended complaint adds Villinger as a plaintiff and asserts 4 counts. Count 1 alleges a claim challenging the board reduction resolution as a breach of fiduciary duty. Count 2 alleges a claim challenging the board reduction resolution under the bylaws. Count 3 alleges a claim challenging the board's rejection of the nomination notice as a breach of fiduciary duty, and Count 4 alleges disclosure claims. In the 2 months leading up to trial, the court resolved a motion to expedite, a second scheduling dispute, 3 discovery motions, a motion to dismiss, and numerous issues at the pretrial conference, including a witness advocate dispute. The court held a 2-day trial on May 8th and 9th. On May 10th, the court denied plaintiffs' motion for class certification under Court of Chancery Rule 23. The parties filed post-trial briefing on May 19th. 2. Analysis. In counts 1, 3, and 4 of the amended complaint, plaintiffs contend that the director defendants breached their fiduciary duties by adopting the board reduction resolution, improperly rejecting the nomination notice, and issuing false and misleading disclosures. To obtain permanent injunctive relief, plaintiffs must show that the merits of their claims are supported by the law and preponderance of the evidence, irreparable harm, and that the balance of the equities favors injunctive relief. Plaintiffs succeed on the merits of Count 1 and aspects of Count 4. Injunctive relief is warranted as detailed below. A. The director defendants breached their fiduciary duties by adopting the board reduction resolution. Counts 1 and 2 challenge the validity of the board reduction resolution as 1. The product of a breach of fiduciary duty, and 2. Inconsistent with the bylaws. Because plaintiffs succeed on the fiduciary duty claim, the court does not resolve plaintiffs' alternative theory under the bylaws. 1. Enhanced scrutiny applies to the board reduction resolution, which was not adopted on a clear day. In Count 1, plaintiffs contend that the director defendants breached their fiduciary duties by adopting the board reduction resolution. As a predicate issue, the parties dispute which standard of review governs this claim. Delaware has 3 tiers of review for evaluating director decision-making: the business judgment rule, enhanced scrutiny, and entire fairness. Delaware's intermediate standard of review, enhanced scrutiny, applies to the board reduction resolution, which was adopted as a defensive measure in the face of an impending proxy contest. Delaware courts scrutinize closely corporate acts that affect stockholder voting. As Chancellor Allen famously stated in Blasius Industries, Inc. v. Atlas Corp., the shareholder franchise is the ideological underpinning upon which the legitimacy of directorial power rests. Thus, in Koster v. UIP Companies, Inc., the Delaware Supreme Court reaffirmed that when a stockholder challenges board action that interferes with the election of directors, the court applies enhanced scrutiny under Unical with sensitivity to the stockholder franchise under Blasius to protect fundamental interests at stake, the free exercise of the stockholder vote, as an essential element of corporate democracy. The board reduction resolution here affects an election of directors by reducing the number of director seats on which Ionic stockholders can vote at the annual meeting. Enhanced scrutiny therefore applies. Defendants nevertheless contend that the business judgment rule should govern review of the board reduction resolution, relying on Open Wave Systems Inc. versus Harbinger Capital Partners, Master Fund 1 Limited. In Open Wave, the court reviewed a board's decision to reduce director seats as a valid exercise of business judgment, where the trial evidence showed that the board's decision occurred nearly 2 months before a proxy contest launched, proving the reduction in the number of board seats was not a defensive measure designed to interfere with the stockholder franchise. Put differently, because the resolution in Open Wave was adopted on a clear day, not in response to a proxy contest, the court did not impose the heightened standard of review applied to takeover defenses or attempts to circumvent the stockholder franchise. In stark contrast to Open Wave, the trial evidence here overwhelmingly supports a finding that the board reduction resolution was not adopted on a clear day. For example, the board knew by August 24th that Fiduciary sought stockholder support for a special meeting to replace Ionic directors. On September 4th, Fiduciary also served a books and records demand, seeking a stock list to aid in that effort. On October 28th, Fiduciary, Figure Markets, and GXD met with the board. Flanders testified that he knew at that meeting that Fiduciary, Figure Markets, and GXD were working together to replace board members on Ionic's board. On December 11th, Perry, Villinger, and 7 other stockholders sent another books and records demand, seeking Ionic's stock list to run a proxy contest. On January 8th and 11th of 2025, Fiduciary told LaPuma that 3,500 Ionic stockholders had expressed interest in calling a special meeting to effectuate board change, and offered to meet to discuss director candidates. When the board met the following week on January 16th, it discussed the hostile activists and their books and records demands. On January 20th, LaPuma sent an email describing Fiduciary as a putative board candidate and aspiring fiduciary. On January 21st, when exchanging messages about Cagney's social media posts, DiFiore told Duffy that we should hire a proxy solicitor if we haven't yet. Flanders admitted at trial that when the board adopted the board reduction resolution on February 6th, he was aware that there was a desire for a dissident slate. Because the board reduction resolution was not adopted on a clear day, but in the face of a mounting proxy contest, enhanced scrutiny applies. Footnote 94 notes that defendants emphasize that a majority of the board members are not up for re-election this year. Enhanced scrutiny, however, is not limited to electoral contests where the entire board might be replaced. Enhanced scrutiny also applies in other situations where the law provides stockholders with the right to vote, and the directors take action that intrudes on the space allotted for stockholder decision-making. 2. The director defendants breach their fiduciary duties by adopting the board reduction resolution. The Delaware Supreme Court's decision in Koster lays out the roadmap for applying enhanced scrutiny under Unical and Blasius. When a stockholder challenges board action that interferes with the election of directors, or a stockholder vote in a contest for corporate control, the board bears the burden of proof. To determine whether the board has met its burden, first, the court should review whether the board faced a threat to an important corporate interest or to the achievement of a significant corporate benefit. The threat must be real and not pretextual, and the board's motivations must be proper and not selfish or disloyal. Second, The court should review whether the board's response to the threat was reasonable in relation to the threat posed, and was not preclusive or coercive to the stockholder franchise. To guard against unwarranted interference with corporate elections or stockholder votes in contests for corporate control, a board that is properly motivated and has identified a legitimate threat must tailor its response to only what is necessary to counter the threat. The board's response to the threat cannot deprive stockholders of a vote or coerce the stockholders to vote a particular way. A. Whether the board faced a threat to an important corporate interest. The board failed to prove that the board reduction resolution was adopted for a valid, non-pretextual corporate purpose. The principal justification offered in this litigation is that the board reduction resolution increased efficiencies, including to have an odd number of directors in order to avoid deadlock and to decrease costs. Importantly, however, there is no contemporaneous record suggesting that the board actually considered those purposes before approving the board reduction resolution. Because the board did not meet to discuss the board reduction resolution, there are no minutes memorializing any deliberation. Nor does the board reduction resolution itself identify the corporate purposes the board sought to achieve through its adoption. Instead, the only evidence supporting the board's explanation for the board reduction resolution is the post hoc testimony of the director defendants themselves. That is not dispositive, but the lack of any record supporting the director defendants' justifications raises eyebrows. Footnote 106 notes an email from Schnate explaining the business reason for the board reduction resolution after it was adopted. Defendants assert that the board discussed at a January 16th of 2025 meeting the need for an odd number of directors to eliminate deadlocks, discussed whether it should be 7 or 5, and decided to take a little more time to weigh that decision. However, minutes of the January 16th meeting do not evidence that purported discussion. Footnote 108 notes that while defendants argue that the board did not consider the potential proxy contest when deciding to adopt the board reduction resolution, they wholly rely on self-serving testimony. Flanders claimed the board discussed all of these issues prior to the February 6 unanimous written consent. Duffy claimed he did not consider the impact of the board reduction resolution on the 2025 annual meeting, and that it wasn't one of the board's considerations when it shrank the board, and that no one raised the fact that shrinking the size of the board would have an impact on the 2025 annual meeting. And LaPuma testified that the decision to reduce the board was not motivated by a desire to entrench herself. End footnotes. The board's shifting explanations in this litigation further evoke skepticism. When opposing expedition, defendants represented that the board reduction was a consequence of Ionic's December 4, 2024 termination of the HUT 8 arrangement. But, as it turned out, HUT 8's termination reduced the board from 8 to 6, not 5 directors. So to explain the second reduction, defendants had to change course to argue that the board reduction resolution was adopted to save costs and avoid deadlock. Those reasons, entirely divorced from the evidentiary record, seem to have been created for purposes of this litigation. To be sure, the justifications for the board reduction resolution that the board now offers have some truth to them. Even plaintiffs agree that saving costs is a valid purpose, and that Ionic does not need more directors. But the board could have explored other solutions for saving costs that did not eliminate a director's seat immediately prior to the stockholders' first opportunity ever to elect directors. There is no record that alternative cost-saving measures were considered. Similarly, setting an odd number of directors to avoid the possibility of deadlock might make sense in many circumstances. But the board reduction resolution here did not really accomplish that supposed goal. Before the board reduction resolution, the board comprised 6 seats with 2 vacancies, resulting in an even number of directors voting. After the board reduction resolution, the board comprised 5 seats with 1 vacancy, still leaving an even number of directors voting until, at some point in the future, Ionic hired a new CEO to fill the final vacancy. Notably, at trial, Flanders offered a different explanation for the board reduction resolution that rang truer than any of the others offered in briefing. He testified that the board did not want to try to recruit a new director into a situation that was such a pitched environment, and was afraid Ionic wouldn't be able to recruit a high-quality board member until it calmed the waters a bit. In other words, only one incumbent Class 1 director remained, and it would be difficult for the board to find a nominee to recommend for the second vacancy at this time. Reducing the number of directors so that the board, rather than the stockholders, could later identify better candidates is not a legitimate corporate purpose. As our case law makes clear, the notion that directors know better than the stockholders about who should be on the board is no justification at all. B. Whether the board's response was reasonable and not preclusive. The board also failed to prove that the board reduction resolution is reasonable and not preclusive. Even if the board had proven its purported objectives of cost savings and avoiding deadlock, the board reduction resolution was not necessary to accomplish those objectives. As noted above, the board could have explored ways to save costs that did not interfere with the director election, and the board reduction resolution resulted in an even number of directors that would not avoid deadlock. The board reduction resolution is also preclusive. For a measure to be preclusive, it must render a successful proxy contest realistically unattainable, given the specific factual context. As this court has explained under similar facts, the board reduction resolution made success in a proxy contest realistically unattainable by eliminating the possibility of success for 2 seats. Before the board reduction resolution, stockholders had the opportunity to elect 2 directors, but after, they could elect only 1 director. By eliminating a seat, the board made it impossible for stockholders to elect directors to that position. By doing so, the board imposed its favored outcome on the stockholders: no new directors. The board failed to prove that the board reduction resolution was adopted for a valid, non-pretextual corporate purpose, or that the board reduction resolution is reasonable and not preclusive. Plaintiffs have succeeded in proving that the director defendants breached their fiduciary duties by adopting the board reduction resolution. B. The director defendants did not breach their fiduciary duties by rejecting the nomination notice. In Count 3, plaintiffs contend that the director defendants breached their fiduciary duties by improperly rejecting a nomination notice that complied with the advance notice bylaw, and that even if the nomination notice did not comply, the director defendant's application of the advance notice bylaw was inequitable. 1. The nomination notice failed to comply with the advance notice bylaw. Advance notice bylaws, provisions that require stockholders to provide the corporation with prior notice of their intent to nominate directors, along with information about their nominees, are commonplace. Advance notice bylaws are designed and function to permit orderly meetings and election contests, and to provide fair warning to the corporation so that it may have sufficient time to respond to shareholder nominations. Consideration of an advance notice bylaws application begins with a contractual analysis that asks, were the bylaws clear and unambiguous? Did the stockholders' nomination comply with the bylaws? And did the company interfere with the plaintiff's attempt to comply? Bylaws are contracts between the stockholders and the corporation, interpreted according to their commonly accepted meaning, unless the context clearly requires a different one, or unless legal phrases having a special meaning are used. If a bylaw provision is ambiguous, courts will resolve any doubt in favor of the stockholders' electoral rights. The board rejected the nomination notice because it failed to 1. Attach copies of the solicitation agreement, September 11th MNDA, and December 10th MNDA, or 2. Disclose the existence of the first group agreement, second group agreement, and third group agreement, among other agreements. The board's second reason for rejecting the nomination notice, the failure to disclose the existence of material agreements between plaintiffs, Figure Markets, and GXD, carries the day. Plaintiffs argue that the nomination notice did not have to disclose the agreements in question because they were no longer operative at the time of the nomination notice. The second group agreement amended and restated the first group agreement on October 7th of 2024. The third group agreement disbanded the group under the second group agreement on October 21st of 2024, and the solicitation agreement terminated the third group agreement on February 14th of 2025, the same day the nomination notice was submitted. Plaintiff's position, under these facts, contravenes the informational purpose of the advance notice bylaw. Informational requirements serve an important disclosure function, allowing boards of directors to knowledgeably make recommendations about nominees and ensuring that stockholders cast well-informed votes. In particular, disclosing agreements, measures, or plans taken towards a common end is critical, not only because there are legitimate reasons why the board would want to know whether a nomination was part of a broader scheme relating to the governance, management, or control of the company, but also because such information is important to stockholders in deciding which director candidates to support. That purpose is ill served if a stockholder omits disclosing an agreement terminated the same day it submits a nomination notice, as plaintiffs did here. There is little doubt that stockholders would want to know about recently terminated agreements when deciding how to vote their shares. The court does not need to definitively resolve whether plaintiffs were required to disclose recently terminated agreements, however. Even assuming plaintiffs were only required to disclose extant agreements, the nomination notice still failed to disclose a material provision in a terminated agreement that expressly survived termination. Namely, paragraph 7 of the third group agreement states that for 1 year, no member of the group shall enter into any agreement, arrangement, or understanding with Ionic relating to the purpose unless such agreement, arrangement, or understanding includes a commitment of Ionic to the following: 2. Negotiating with the company and taking such other actions as may be necessary or advisable, including, without limitation, pursuing the calling of a special meeting of the stockholders of the company to enter into a cooperation agreement with the company containing customary non-disparagement provisions and the agreement of the company to cause c. the formation of 2 new committees of the board, one to lead the search for a new CEO, which committee will include at least 2 of the new directors, and which committee will consider Mike Abate as a candidate for CEO, and one to conduct a strategic and operating review of the business, which committee will include at least 3 of the new directors, and will 1. Consider terminating the contract between the company and U.S. Data Management Group, LLC, and consider GXD as a replacement provider of the services currently provided by Hut 8, and 2. Consider listing the securities of the company on Figure Markets ATS market. Plaintiffs do not argue that the agreements reflected in paragraph 7 is immaterial, only that it is moot because the focus of the group has shifted from holding a special meeting to running a proxy contest at the annual meeting. Importantly, however, nothing in the record suggests this contractual obligation was terminated or waived before the nomination notice was sent. The existence of a commitment to support the types of proposals described in paragraph 7 would have been important to stockholders in deciding which director candidates to support. Plaintiffs have therefore failed to show that the nomination notice complied with the advance notice bylaws disclosure requirements. Footnote 124 notes the plaintiff's response to the third group agreement's paragraph 7 disclosure. The Selly was asked, and this contract says under paragraph 7, this obligation shall survive any termination of the agreement, right? To which was answered, yes, but this is impossible unless a special meeting. Perry responded, again, parties have changed, it's irrelevant. And Villinger responded, I cannot speak to this because I understand that the provision is not in effect today. And footnote 125 notes, while plaintiffs argued at trial that Figure Markets and GXD could submit letters confirming that the parties have waived or terminated paragraph 7, they conceded such letters were not prepared before the nomination notice was delivered. 2. The board's rejection of the nomination notice was not inequitable. The Delaware Supreme Court wrote 50 years ago in Schnell that inequitable action does not become permissible simply because it is legally possible. Thus, the court's analysis does not necessarily end if a stockholder fails to comply with the plain terms of an advance notice bylaw. Instead, Delaware law necessarily leaves room for assessing whether a board's actions in enforcing a clear advance notice bylaw were justified, consistent with the doctrine of Schnell. Under Koster, because the board's rejection of the nomination notice implicates a director election, the court applies enhanced scrutiny with Blasius gloss to determine 1. If the board rejected the nomination notice for legitimate rather than pretextual, selfish, or disloyal reasons, and 2. If the rejection was reasonable and was not preclusive. The board bears the burden of proof. A. Whether the board faced a threat to an important corporate interest. The board proved at trial that it rejected the nomination notice to advance important corporate interests. The advance notice bylaw's disclosure requirements serve legitimate objectives. Directors and stockholders justifiably want to know whether a nomination is part of a broader scheme. The concealment of arrangements and understandings that go to the heart of a nomination effort risks undermining the essential disclosure function of advance notice bylaws. Rejecting a nomination notice for failing to disclose plans or proposals promotes the disclosure function of advance notice bylaws. The board here appropriately concluded that the objective of preserving an informed stockholder vote was threatened. Plaintiffs contend that the board's decision to reject the nomination notice was preordained and pretextual, focusing on the brief timing between the board's receipt of the YCST memo and its decision to reject the nomination notice. But the context in which the board received the nomination notice cannot be ignored. The board knew that the plaintiff's nomination notice was backed by 2 non-stockholders motivated by separate commercial interests. The director defendants credibly testified that they believed understanding the specifics of all arrangements between plaintiffs, Figure Markets, and GXD would be highly material to stockholders deciding who to support at the annual meeting. Plaintiffs also argue that the board's conduct in dealing with Ionic stockholders casts doubt on its motives for rejecting the nomination notice. This argument is not frivolous. To some extent, the board's inequitable adoption of the board reduction resolution colors its rejection of the nomination notice. Plaintiffs also contend that the board strategically timed announcement of the annual meeting to minimize the number of days in which a nominating stockholder could submit a nomination notice. But weighing all the evidence, I remain convinced that the board properly rejected the nomination notice to advance a legitimate corporate purpose. Separately, plaintiffs assert that the board acted inequitably by failing to provide them an opportunity to supplement the nomination notice before the nomination window closed. The nomination window closed 2 days after plaintiffs submitted the nomination notice. On that truncated timeline, I cannot find that the board's failure to respond sooner amounted to manipulative conduct. Footnote 128 notes, rejecting the September demand in part because the purpose included pressuring Ionic to trade on Figure Markets platform rather than NASDAQ, conditioning production of the stock list on the outside funds provision. The board notes and stresses that Alshon represents Figure Markets, who is not a stockholder of Ionic. Meeting minutes stating that the board discussed concerns that without complete information in the notice, stockholders would not be able to properly vet proxy solicitations from the dissident stockholders who are financially backed by non-stockholder third parties. And footnote 129 notes, Flanders was quoted as saying, The connection to figure markets and GXD was a concern to me. The big concern that surfaced was that in the nomination notice, not every agreement had been disclosed, and some that had been disclosed had not been attached. And Duffy was quoted as saying, "We discussed the documents that were submitted along with the nomination notice, and then discussed documents that were later produced through discovery at the Books and Records case that were not submitted with the nomination notice, and why they should have been, and ultimately why the nomination notice should be rejected there because of the lack of disclosure." And LaPuma was quoted as saying, explaining that the purpose of the advance notice bylaw is to provide transparency to shareholders about who is being potentially nominated or put forth as a candidate to be on the board of a company. And footnote 130 states, the February 6th press release resulted in a nomination window that closed on a Sunday, such that nominating stockholders who requested a director nominee questionnaire on the day the press release issued would have just one business day to submit a completed nomination notice if Ionic used the entire 5 business day period to produce the questionnaire. In actuality, Ionic produced the questionnaires on February 12th and allowed plaintiffs to submit the questionnaires on February 17th, such that plaintiffs had 2 business days to complete the questionnaires. B. Whether the board's response was reasonable and not preclusive. The board also proved that its enforcement of the advance notice bylaw was reasonable and did not preclude plaintiffs from submitting a complaint nomination notice. Enforcing the advance notice bylaw is a reasonable means of ensuring that stockholders receive material information about director nominees. And although plaintiffs argue that the board strategically timed announcement of the annual meeting to minimize the nomination window, plaintiffs did, in fact, submit a timely nomination notice. Plaintiffs could have complied with the advance notice bylaw's disclosure requirements, but they did not. The record does not support plaintiffs' position that the board's rejection of the nomination notice was unreasonable or preclusive. C. Irreparable harm, balancing the equities, and the nature of the injunction. As set forth above, plaintiffs succeed on the merits of Count 1. To demonstrate their entitlement to mandatory injunctive relief, plaintiffs also must establish irreparable harm in the absence of an injunction, and that the balance of the equities favors injunctive relief. Both requirements are met. Courts have consistently found that corporate management subjects shareholders to irreparable harm by denying them the right to vote their shares. Without some form of injunctive relief, Ionic stockholders will be prevented from exercising their voting rights by electing 2 directors at the annual meeting. This loss of voting power constitutes irreparable injury. Balancing the equities also supports injunctive relief. In the absence of an injunction, stockholders risk losing sacrosanct voting rights. Defendants, on the other hand, face no hardship from an injunction. Even when the incumbents themselves could be voted out of office, that fact does not support a claim of hardship. Plaintiffs have established their entitlement to an order invalidating the board reduction resolution and restoring the board to 6 directors, including 2 Class 1 directors. The parties disagree, however, on the effect that remedy should have on the annual meeting, given that the board has proposed only 1 director nominee and plaintiff's nomination notice proposing 2 other director nominees was properly rejected. Defendants point out that ordinarily, if a vacancy exists on a classified board, the remaining directors fill it by appointment until the next stockholder meeting. But the crux of Count 1 is that the director defendants breached their fiduciary duties by inequitably interfering with the corporate election, by reducing the number of directors that Ionic stockholders will elect at the company's first annual meeting. A remedy that would permit the directors who breached their fiduciary duties to choose who will serve on the board is no remedy at all. Instead, to appropriately restore the stockholders' ability to elect 2 Class 1 directors at the annual meeting, an injunction will issue directing the board to reopen the 10-day nomination window under the advance notice bylaw to allow the board, plaintiffs, and any other Ionic stockholder to submit director nominations. Defendants assert that plaintiffs should be categorically barred from submitting a new nomination notice, regardless of how many seats are up for election, because allowing plaintiffs to nominate candidates despite their noncompliance with critical requirements in the advance notice bylaw would undermine the purposes and integrity of advance notice bylaws by rewarding stockholders for concealing material information. Under the unusual facts of this case, I disagree for two reasons. First, it is true that in most circumstances, plaintiffs would not get a do-over after failing to comply with the advance notice bylaw. But here, it is not plaintiffs but the board's wrongful conduct that necessitates reopening the nomination window. Second, the trial record does not support defendants' position that plaintiffs intentionally concealed material information. To the contrary, plaintiffs produced the undisclosed agreements at issue, including the third group agreement, in the 2020 action within days of submitting the nomination notice, and have openly disclosed Figure Markets and GXD's involvement in the proxy contest. Defendants offer no real reason why plaintiffs should not be permitted to submit a new nomination notice during the reopened nomination window, so that, with the benefit of full disclosure, Ionic stockholders who have not been able to exercise their voting rights since the company's incorporation can finally decide for themselves who should serve on the board. D. Defendants must correct disclosures about the board reduction resolution and the annual meeting. Count 4 asserts the claim for breach of fiduciary duty premised on disclosure violations. Plaintiffs seek an order requiring corrective disclosures to remedy the purported violations. When directors communicate publicly or directly with shareholders about corporate matters, the sine qua non of directors' fiduciary duty to shareholders is honesty. It is well established that the duty of disclosure represents nothing more than the well-recognized proposition that directors of Delaware corporations are under a fiduciary duty to disclose fully and fairly all material information within the board's control when it seeks shareholder action. Information is material if there is a substantial likelihood that the disclosure of the omitted fact would have been viewed by the reasonable investor as having significantly altered the total mix of information made available. Plaintiffs first argue that Ionic disseminated false and misleading disclosures, stating that only one Class 1 director seat is up for election at the annual meeting. To ensure that stockholders are fully informed, Ionic must disclose the court's ruling in this action, including the new date of the annual meeting and the court's order that the nomination window be reopened for 10 days to permit any Ionic stockholder to nominate directors for the two Class 1 seats up for election. Plaintiffs also argue that Ionic disseminated false and misleading disclosures stating that the nomination notice failed to comply with the advance notice bylaw. Those disclosures are true, so corrective disclosures are unnecessary. Finally, plaintiffs contend that Ionic disseminated false and misleading disclosures concerning Figure Markets and GXD. Plaintiffs argue that a March 26th press release falsely stated that plaintiffs' nominees will cause Ionic to enter value-destructive contracts with Figure Markets and GXD. Plaintiffs have not demonstrated that this disclosure, which reflects on the board's opinion, is false, let alone that it was made carelessly or disloyally. Similarly, plaintiffs contend that Ionic issued disclosures claiming that Figure Markets and GXD leveraged plaintiffs to file the 2020 action in their name. Plaintiffs are acting on behalf of Figure Markets and Michael Cagney in the proxy contest, and plaintiffs seek to elect the dissident nominees to advance the financial interests of Mr. Cagney and Figure Markets. Again, plaintiffs have not proven that such disclosure is false or is made carelessly or disloyally. 3. Conclusion. For the reasons explained above, judgment is entered for plaintiffs on Count 1 and aspects of Count 4, and an injunction will issue as set forth herein. Judgment is entered for defendants on Count 3. The parties are directed to meet and confer on a proposed form of order to implement the rulings in this memorandum opinion. To conclude, some final footnotes. 137 states, plaintiffs relatedly argue that on March 26th, Ionic issued a press release stating that the company published its amended bylaws on its website on February 20th of 2025, which differs from the group's claim that was added after the group had submitted their notice. That statement is misleading because it suggests that the board disclosed the board reduction resolution before plaintiffs submitted the nomination notice, which is false. But given the court's rulings herein, I believe a disclosure correcting that misstatement would cause further confusion. The court, therefore, will not order Ionic to make corrective disclosures addressing that specific statement in the press release. And footnote 140 cites Consolidated Fisheries Company versus Consolidated Solubles Company, wherein the judge ruled it is the general rule that mere expressions of opinion cannot be deemed misrepresentations. Footnote 143 states, plaintiffs contend that the court's post-trial ruling in the 2020 action contradicts Ionic statements, but it does not. The court issued a narrow finding that the plaintiffs had a proper purpose for seeking a stock list, explaining that Fiduciary did not lend his name to the stock list demand, and that plaintiffs were not proxies, surrogates, or shills for Figure Markets and GXD. The court did not determine whether Figure Markets and GXD leverage plaintiffs to obtain books and records, or whether plaintiffs are acting on behalf of Figure Markets and GXD to advance their financial interests in the proxy contest now. And footnote 144 states, the parties also seek an order shifting fees. The court declines to issue an expedited ruling on fee shifting. The parties are not precluded from moving for fees if they deem appropriate.